Welcome to literary and jury charge practice. Let's get started with some jury charge. Ready? The fact that all evidence pointed to him did not mean that he was guilty. In the end, the defense attorney discovered that the wife of the defendant has the same type of glasses as those worn by the victim. The defense attorney realized that the defendant and the victim did not have an affair. The evidence that pointed to the defendant did not prove that he had committed the crime. Then there was the defendant's wife. The defendant's wife was having an affair with the victim's husband. All right, that was just a short little jury charge warm-up. Now let's do some literary material. Let's practice some literary, and this is one we've already started regarding writing the Stanley Cup. It's an article in the Journal of Court Reporting by Connie Lee. She captions it, so let's read a little more about it. Ready? What was so amazing to me was that Billy started his instructions by saying, "The people that are here in this room are here because I trust you. You are the best of the best." That's what made me realize I write the Stanley Cup every day. Like the hockey players, I practice and hone my craft. I invest a minimum of 40 hours a week to my career. I don't waste my time doing it halfway. Everything counts. Every stroke, every interaction with my clients, every conversation with my support staff, every time I speak with the subcontractors, everything counts every day. I get tired, sure, and sometimes I think of walking away, but what I do is important to more than just me. My team is counting on me. My family, my office manager, my scopus, my proofreader. More than anyone, the people who hire me and trust me with their work are counting on me. When I write for the lawyers, I may not be the superstar on the ice, but I most equate myself with the equipment manager, making sure their skates are sharp so that the litigators can go out and win. When I write for the Penguins, an entire fan base of people is counting on me to be their ears and to give them the full game night experience. I pride myself on being the one both groups can rely on to do my absolute best every day. My sweet Penguins did not win Game 5. It broke all of our hearts. The responses to the interviews after the game were not of the team giving up. They were of each player filled with resolve to get the job done, to come back next game and win the Stanley Cup in Game 6, which they did, and I was there with them. Very interesting. All right, let's get back to some jury charge. Ready? Let's see here. Let me see if there's any words that might be challenging. We have incarcerated, parole, malice, malice aforethought, malice aforethought, conspiracy, allegations, all right, ready? If a person is incarcerated and received a parole, he is left out of prison. If a person committed a killing with malice aforethought, he might have trouble getting a parole. The attorney tried to show that the defendant did commit the crime with malice aforethought. The crime the defense attorney said that the individual was charged with was not committed with malice aforethought, even though it was considered to be a serious crime against the United States. The crime of the individual was said to be that of conspiracy to commit a crime. He argued that the defendant did not participate in any type of activity that would suggest a conspiracy. He indicated that in the complaint that was filed against the individual at the time, it was wrongly alleged that this particular individual had participated in an activity that he could not possibly have been involved in. He alleged that he was not capable of acts that would cause harm to individuals who were of the United States. not living in the United States. These allegations contained in the complaint were among those questioned by the defense. The defense attorney indicated that the allegations of the complaint did not in any way mean that there was probable cause. The complaint alleged that the conspiracy was to kill nationals of the United States outside of the United States. Of all of the complaints, the defense alleged that there was no indication that any violence occurred. The defense alleged that the only crime of violence alleged by complaint was in error. He indicated that it did not mention violence. He said it stated that engaging in a conspiracy to kill nationals of the United States outside of the United States is a violation of the law. The reference to the violence is contained in the reference to the words that are found in the complaint. All right, now for some literary material. Let's see what we have. This article is called "What Should You Do with Those Old VHS Tapes?" Ready? Recently, I went fishing in a storage closet in my house to find an item I thought my daughter would enjoy playing with, and I found 4 medium-sized boxes bursting with VHS tapes that I had forgotten about. They were not old movies. No, they were legal video depositions. Each tape consists of a legal case of some kind being told from the viewpoint of the person being questioned. Always the same shot, just the deponent with a visible time date stamp. Why do I still have them? Court reporters are required by law to keep the stenographic record for 7 years. Certified legal video specialists debate on keeping video depositions between 5 to 7 years. VHS tapes do not have a very long life, especially if they are not kept in an environment with an even 62 to 72 degrees and in one that is not too damp nor too dry. When I started working in legal video, VHS was the standard format used for both the cameras and the backup copies made with a VCR. In 2004, I began using a mini DV camera with a VHS backup because VHS was still requested. In early 2008, I stopped using VHS as a backup copy and went to a backup DVD burner. I now see a trend of backing up to a flash drive or something of a similar digital likeness, which would help videographers everywhere lighten their gear bag even more. In 2012, I started using an SD card camera, which further reduced the need for physical storage and carrying stock. These days, I only need to pack DVD stock until I switch to the digital backup. So here I am staring at several boxes of VHS tapes. What on earth do I do with them? The thought of simply leaving them out for the trash truck created images of seeing a future news story of the mess choking some birds or killing off already endangered sea life. Next, I thought of them being in a dump, melting under the summer sun and polluting the ground, or even worse, contaminating the water table. No, I cannot simply have the trash collectors haul it off to some unknown to me destination. As I began to ask around, I found fellow legal videographers and videographers in general faced with the same situation, which has kept most of us holding on to these memories and forgotten stock longer than necessary. Alright, we'll have to get back to that one. Okay, we'll get back now to our jury charge. Ready? The defense of the defendant was based upon the fact that the defendant joined the forces long before the United States had any presence in the area. The defendant did not have any knowledge of the involvement of the United States in that area because at the time there was no involvement. The defense attorney disputed the fact that the defendant had anything to do with any conspiracy against the people of the United States, as he was engaging in the activity long before there was any presence of the United States forces in the area. It was not possible for him to have any involvement with any conspiracy against the people of the United States, as the United States was not involved in the area at that time. He said that there was no basis to allege that the defendant participated with any intention to harm United States nationals, as no United States nationals were involved with the issues with which he was involved at the time. All right, that will conclude our literary and jury charge practice. Thank you.